Testing Justice 1. Testing Justice 2. Testing Justice 3. Testing Justice 4. Testing Justice 5. Testing Justice 6. Testing Justice 7. Again, testing 1. Testing 2. Testing 3. Testing 4. Testing 5. Testing 6. Testing 7. Testing podium. Testing 5. Testing 7.
The first matter before the court is Knox 25-378, the estate of Dominik Lobkowicz. I see counsel are present. I'm assuming you're ready to proceed. What I'm going to ask is that before we begin the argument, which is being streamed on the web, both by audio and video, that you introduce yourselves by saying your names for the record together with the party you represent, starting with the appellant.
Morning, Your Honor. My name is Daniel Cummings from Norman Hanson, Detroit. I represent the appellant, Christopher Stefanoni.
Good morning, Your Honors. My name is Justin LeBlanc from LeBlanc Diggins. I represent the appellee, Nicholas Lobkowicz, personal representative of the estate of Dominik Lobkowicz.
Thank you, Attorney Cummings. We're happy to hear your argument here this morning.
Court. Today, I think the argument, at least from my perspective, is fairly straightforward, and that's simply how do we construe Section 3-108 of the probate code.
Can I, since you decided to let the green light go on right away, how does your client have any standing? I mean, can just anybody, could I come in and petition to remove a personal representative on anybody's estate?
No, you have to be an interested party.
Well, how is your, I mean, your client didn't check anything on the boxes that he's not a beneficiary, he's not a personal representative, he's not a potential heir, he's not, I mean, how is, there's nothing in the record, as far as I could see, indicating that your client has any interest whatsoever in the litigation.
Well, a couple things. He checked off one of the boxes that was on the form that the probate court provides.
But that doesn't
Yes,
establish.
I didn't invent the form, Your Honor.
But it just says other.
And there was no challenge below to standing either.
Can't we notice that whether they're standing on appeal sua sponte?
I think that's been waived below. I mean, if you have subject matter jurisdiction, I understand that, but there wasn't any challenge. There was an ability for my client to prove, if anybody had a concern, that he didn't have appropriate standing. But he's either a devotee or a transferee of a devotee. So I think clearly under the
That
code,
anywhere in the record? I mean, the will was filed. He's not in the will.
No, he's not. No, I understand. I understand. But again, no one challenged standing, Your Honor. That could have been an issue that we litigated and could have easily proved if somebody thought there was lack of standing.
But standing is jurisdictional. We can address jurisdiction even at this level up here. And I think the Chief's questions are, what is the basis for standing, just to make sure that we have jurisdiction over this case?
Well, I think the court clearly had jurisdiction as far as subject matter jurisdiction goes. And the question, if somebody lacks standing or not, is something that needs to be challenged at the time that the
Well, it goes to the justiciability of the claim, doesn't it?
I'm sorry.
It goes to the justiciability of the claim.
It can, if somebody challenges that fact, it goes to a determination of whether there's appropriate standing or not. But nobody said a word.
You always have to have standing. And just because you had standing below doesn't necessarily mean you meet our criteria for standing. But so why do you think you are an interested party?
Because my client holds title to property that came devised through the will to, I think it was his aunt. So he currently has title to property that's being the subject matter potentially of the action that was brought by the personal representative.
But why would he, I mean, I don't mean to divert us from standing, but just getting to the merits, if the sole limited purpose of the personal representative coming in is to confirm title, then wouldn't that benefit your client?
Well, a title is confirmed by the fact that the will was probated. The probate of the will has determines who the devisees are under the will, and the devisees under the will are the ones who have title under the probate.
But your client's not a devizee.
No, but he's a successor to a devizee as far as title goes, and that's what we're talking about here, is who has title to property and whether there's a necessity in the estate to establish whether there's title or not.
Let's
And
put this
that
another-
occurred upon the filing, probating of the will.
Counsel, let's put this another way. How is your client aggrieved by the appointment of the younger Mr. Lobkowicz as personal representative?
Because of his fact that he has title to the property, so he's entitled to not have interference that violates the statute. The statute is clear that there's no
Okay, so
appointment. Yeah.
let's talk about, though, the petition for removal here. I guess we'll put aside standing for a moment. I'm looking at 3611, and I don't see, I understand you've made a statute of limitations argument here, but that's not one of the grounds for removal under this provision of the statute. So how is this procedurally a proper mechanism?
I think, Your Honor, that that was raised below.
I understand the probate judge sort of skipped over that issue and went to the merits, but I'm concerned that it's not a procedurally proper
may not skip.
mechanism.
Sorry.
I said we might not skip always.
Yeah, well, again, it was offered up that an amended complaint that if the petition weren't a proper vehicle to get the issue before the court, and I think, at least I viewed it as implicitly the court accepting that because it moved on to the issue that was within the proffered complaint.
Well, what would you suggest we do if we conclude that the petition was not a proper vehicle to get the issue before the court? Can we, it seems odd to me that we would sort of grant the motion to amend in the first instance. I mean, there might be issues with whether, for example, with standing to bring a declaratory judgment in this circumstance. So would the appropriate thing in that instance be to, in your view, remand if we decided that the petition was not proper, to allow the probate judge to consider the motion to amend? What should happen in that instance?
If you, I think that, I guess the short answer is yes, if you view that the fact that the court went on to take on the issue that was contained in the proffered complaint in connection with the motion to amend as not being essentially approved, if not expressly, but implicitly by the court and addressed at the time, then I guess the answer would be yes. But I think it seems like we'd be right back there with an exact same legal issue.
Let me ask you about a different provision of the code then. 33072 talks about personal representative. The office of that is not, it's subject to termination and we just talked about sort of the termination procedures, but it's not subject to retroactive vacation. As I read, I think one way to read the code is that once someone is appointed, they're appointed subject to these various grounds for removal, which I don't think you've alleged here. But what you're trying to do is retroactively vacate it. You're trying to say it was void sort of as the moment it was entered, and I'm not sure the statutes allow for that. So what do we do with that language that says a personal representative, that office is not subject to retroactive vacation?
Your Honor, there's got to be a way that a challenge to a register of probate issuing letters of authority can be challenged. Now,
But it's not our job to tell you what that way might be, is it?
no, it isn't. But it can't be simply that it gets appointed and there's no way to get it. You got to get to the, I admit, you got to get to the probate judge. So the question is, how do you get the issue before the probate judge?
Well, there are options. Someone can seek to be appointed themselves, right? File for formal appointment and challenge.
Not if my reading of the statute is correct, because there had been a prior probate proceeding within the 3 years after the decedent's death. So appointment of a personal representative after that 3-year period is inappropriate. So you wouldn't have somebody else to be appointed in the place of somebody who shouldn't have been appointed, because no one should be appointed.
Counsel, do you think that Rule 60B could have been used to challenge the entry of the appointment order?
No.
Why not?
Because it was an informal application that was letters of authority issued by the Register of Probate. So there was no judgment, no order that would be subject to Rule 60. And so, yeah, question is getting it before the judge, I guess, in the first instance, so to speak, for a ruling. But I don't,
So is
Rule 60 would not be the way.
concern for why he wants to be the PR because he wants to settle who has title to certain property?
Again, that's the purpose of the probating of the will within the 3-year period. That's what establishes.
But is that why he cares? Is that why he's aggrieved? He wants to settle the title issues. Is that why he cares?
Why he cares about the trustee being appointed?
Yes, and he wants to be the PR. Why is he concerned about that? Is it to nail down that he's got title in certain property?
Your client is opposing the appointment,
Yes.
not seeking an appointment.
So you
Correct.
don't
Correct.
want him to be able to do this. I'm just
Right.
not understanding
Yes.
why people care about who the PR is.
Again,
Why don't you want it to be him? Why?
because it shouldn't be anyone. There's no PR to be appointed after the 3-year period, date of death, if there is a proceeding before
Okay,
filed
so
before the
your
court.
position is no one should be a PR.
Exactly.
So in order to settle title about the property, your point is you have to go file a quiet title action.
Potentially, not necessarily, but depending on circumstances, maybe, but not necessarily.
The probate judge.
I may, without getting a probate, without getting a quiet title action, I still may be able to, because I'm a devisee, I got the will probated, I got the probate code telling me the property devolves to devisees immediately upon death.
The
that I may be able to
probate judge,
transfer title
the
and
probate
get
judge,
title
the
insurance
probate
without any of
judge,
that.
the probate judge seemed very concerned about the implications of your position. Why is that?
The probate court?
The probate court, yes.
Yeah, the only thing I can
The
say
court
is
seemed to think this
didn't
was.
give much thought to it, as best I can tell, to be honest with you, when looking at the opinion. There was no real analysis to it. It talked about that, the purpose of section, 3-108 was to allow somebody in to determine title. But again, that's the construct of the code, is that once you have a will probated timely, you already have that determination of title. We know it's in the devisees under the will, based on the provisions of the code that says it
Thank you,
devolves to
counsel.
devisees immediately upon death.
Does anyone else have any additional questions? All right, thank you. And Attorney LeBlanc?
Madam Chief Justice, and may it please the court, my name is Justin LeBlanc, and I represent the appellee Nicholas Lobkowicz, who is the son of the decedent Dominik Lobkowicz and the personal representative of Dominik.
I see you also left the green light on from the beginning. What is the mandate, from your perspective, what does the mandate in this case say?
I'm sorry, Your Honor, what does the mandate say?
Yes, what do we say? In other words, let's assume we think, I think Justice Lopez asked this earlier, let's assume we think that there really is no basis on a petition for removal to challenge it on the grounds that it's being challenged. What does our mandate say?
I think you uphold the probate court's decision, and there are several grounds to do that. There are, at 3611, lists the reasons to remove a personal representative. None of those reasons have been alleged here. There's no malfeasance. There was no.
And assume we agree with you that none of those grounds are alleged here.
And then the probate court order would stand, and Nicholas Lobkowicz would be the personal representative of the estate and in charge of marshaling the assets and distributing them to the successors in interest.
What about the motion to amend that Mr. Stefanoni filed? I think perhaps being alerted by some of your filings below that your view that this was not a proper petition. Has the probate court ruled on the motion to amend?
I don't know as a technical matter if the probate court ever sort of went through each successive step there. Both parties were asked to brief on the timeliness issue, but I think the probate court's interpretation of 31081D provides sort of several off-ramps to get there. As your honors noted, there's a standing issue. There's the issue of, there's an informal probate application, and does that rise to the level of a proceeding concerning succession or estate administration? And if it does, then any type of proceeding filed days before the 3-year statute of limitation then forever bars any other proceeding. And that goes against sort of the purpose of 31081D itself and the entire probate code.
If we could just go back to the procedural issues here. We have asked some questions about standing. You've just mentioned standing. I don't think it was raised below. Do you think that's fair?
It wasn't argued below, Your Honor. We indicated that there was, that Mr. Stefanoni did not appear to be an interested party as defined by the code in our pleadings below, but we did not push that issue. We sort of jumped right to the substance of the matter.
And so if we had a question about whether there would be standing, for example, to bring a declaratory judgment action, would it be appropriate to remand, sort of tell the probate judge, you consider the motion to amend in the first instance, give them an opportunity? Because he suggested that there may be information that does give his client standing. It's just not in the record given the way this was litigated below.
Well, yeah, I think there's nothing in the record to indicate there's any connection to this estate, so I'm sort of at a loss. If this were remanded for a determination of standing, then I think we're sort of, as Attorney Cummings said, we're sort of right back to where we are today, which is, okay, so he had standing to file an informal application. Is that informal application sufficient to satisfy the requirement that it be a proceeding concerning succession or estate administration? And the court below determined that it was not. To do so thwarts the entire purpose of 31081D.
What about the plain language of the statute, though? I mean, it talks about a prior proceeding. You've suggested ways that doesn't apply here, but if you took a very sort of strict textualist approach, I think they may have a strong argument that the informal probate was a prior proceeding. And so I understand the probate judge's concern about that leaves us without a personal representative, but the statute says what it says.
The statute says what it says, Your Honor, yes, but the statute throughout the probate code talks about sort of these common proceedings, a testacy proceeding, an appointment proceeding, a probate proceeding, both formal and informal. And in 3108, it says you can have any of those proceedings so long as there has not been a proceeding concerning succession or estate administration. If, as appellant would have you interpret that statute, he's arguing that proceeding concerning succession and estate administration is synonymous with, and then take your pick, an informal probate application, a formal probate proceeding.
Well, how is an informal probate application not concerning succession? I mean, isn't that the entire point?
Well, an informal probate application, doesn't automatically constitute a proceeding concerning succession. I think it relates to a will and it begins the process, but this is an administrative task accomplished by the register. There's no opportunity for hearing, there's no testimony, there's no record. It's an administrative decision. So I would argue that it does not rise to the level of a proceeding concerning succession.
Can an estate be fully settled through an informal proceeding?
It can, Your Honor, yes.
Then, so if it's fully settled, then it does pertain to succession, doesn't it?
Certainly there are facts and circumstances where outside of the realm of 31081D, there could be other facts and circumstances where an informally probated estate that is in fact administered sort of comes to the point where there's functional finality, where, if distributions have been made and we can rely on that. But here, there was simply an application filed, didn't check the box to appoint a personal representative, and as such,
Is it your position that if we interpret it as Attorney Cummings would argue, then essentially anything it becomes a proceeding, a proceeding regarding succession or administration of a state that is filed? And if that's what the code meant, why doesn't it say that?
Right. At the beginning of 3108, it lists those common proceedings, and then it says you can commence those proceedings beyond the 3 years so long as there isn't, and it doesn't go back and mention those proceedings again. It mentions proceedings concerning succession or estate administration. So I think textually it has to mean something different, or why wouldn't they use the same words? But Your Honor is correct. The concern is that then someone can file an informal application and forever bar the administration of the estate. The entire probate code is set up to be an efficient, effective, informal one.
But it does allow, I mean, there is a pretty substantial statute of limitations, so we can say all that, no, that would be terrible, except I don't know what happened in this case, but the informal application was filed, 2 days before the 3 days ran, and the 3 years ran, and then the request to be appointed personal representative happens 5 years after the death. I mean, so I don't know what's going on behind the scenes, but there was nothing efficient about that.
Well, Your Honor, I think as Judge Emery noted below, 31081D is often used. I mean, this is...
Is it often used, though, because nothing else happened in that 3-year period? In other words, there's no, well, if nothing happens, if the statute runs and there's been no formal proceeding, then you get to subsection 1, right?
Correct.
And so isn't that how it's often used? Whereas here there was a proceeding relevant to succession.
I think there are times, Your Honor, when someone will file a will, if you will. They think there's nothing to probate, so they'll just file the will with the probate court and not seek to probate it. And so you're right that Judge Emery didn't get into, is it this specific use of 3108? Is it that there has been a proceeding? But you noted that it is used a lot, and I think recognize that because it is used a lot, if the answer is any informal proceeding before bars all after, you're really undercutting and I think eliminating any of the benefits of 3108D. I will note that 3108D was just amended last year. It doesn't impact this matter, but I think that shows that this is a statute that is regularly used.
Suppose we decide that we disagree with your interpretation of 3108, but we also don't think it was that a petition for removal is the proper way to raise the issue. Is there a way for another party to raise the issue, and what would it be?
Oh, absolutely, Your Honor. As Attorney Cummings noted, I mean, so his client's initial application was informal. Our application to be appointed was informal. In the normal course, and I think this happens frequently, someone files a will informally. It's an administrative task of the register, and then someone comes and says, I have a new will. I have a will that was signed later in date. That becomes a formal petition, and you get to the judge. I think the issue here is And that's essentially what Mr. Stefanoni attempted to do by saying, by filing a petition to remove. The problem is that there's no reason to remove. And I agree with Attorney Cummings. I don't think a 60B motion is appropriate because there's no final judgment. So
His argument, though, is that the statute of limitations has run. And so paradoxically, if he's right on that, he's also precluded himself from filing a sort of formal, for formal proceedings to have a different PR appointed. So he's stuck. What does he do?
I suppose some sort of declaratory judgment action that could get to the judge where he would have to state what his interest in the estate.
So you think that is a proper mechanism for getting this timeliness issue?
I think that could work. Yes, Your Honor.
In the probate court or in the Superior Court?
The probate court.
And so then I guess we're back to what our mandate
have
is. If
jurisdiction
we think that the petition was not proper, is it, the court was right to dismiss the petition, but remand for further proceedings on the motion to amend to let the probate judge consider that in the first instance? I know you'd prefer that we just affirm, but what do we do with that motion to amend to bring the DJ action?
I think in essence, and to Your Honor's earlier question about, did the probate court specifically rule on the motion to amend? I think in reality, the probate court treated this as a declaratory judgment action and concluded that no, this, it all comes back. So we could remand and we could have that argument, but it's going to come back to, does the limitation in 31081D include an informal probate application? And the judge squarely answered that question, that it does not.
Does the probate court have jurisdiction over declaratory judgment action? I mean, it's a statutory court. The declaratory judgment action is a creature of statute. Why does the probate court have jurisdiction over declaratory judgment?
As a practitioner who limits his practice to estate planning and trust and estate administration and has never been inside a courtroom to litigate something, I don't know the answer to that question, Your Honor, but I think what was filed was akin to that.
But the Superior Court has concurrent jurisdiction, does it not here?
Superior Court has concurrent jurisdiction over some aspects of the probate code, but not who should be appointed personal representative.
Well, it would in an instance where the issue is this one, isn't it? I mean, it would have jurisdiction if a declaratory judgment action were filed to resolve this matter.
To resolve the matter of whether or not Nicholas was properly appointed? I don't think so.
Do you think the probate court has exclusive jurisdiction
Over
on
appointment.
3611?
Over appointment proceedings, yes. Thank you.
Attorney Cummings?
Button for punishment, so. I just want to say, with regard to the informal probate that was filed, I can't be anything other than a proceeding concerning succession. It goes to the very heart of what probate is, and the reason for it is to file and establish title to devotees. And so it was clearly within the scope of 3108. And there is a certain balancing act even with 3108, and that is the 3-year statute of limitations as opposed to some narrow circumstances as to whether something can get filed after that 3-year period. But the fact is to say, oh, there isn't a personal representative, and what are you going to do without one, as if that's the end-all, the be-all, you have to have a PR. That's not the case, and the code's not set up that way.
Is the filing enough? In other words, you file it, but then take no further action? The state is not settled?
Yes.
Is that enough to
Yes.
forever freeze the situation if the estate's never settled?
Well,
Was this estate settled?
yes, I guess the answer is yes, and that's the reason somebody would do it is to get title established. And people get noticed, they have a chance to challenge whether the will was valid. I think section 3-108 even has a provision that talks about having time to do a contested informal probate. So it gives the time the later of, I think, the 3 years or 12 months after the filing of the probate. I think that's one of the exceptions in 3-108. So it gives people opportunity to say, we don't think this is the correct will. But that's the very purpose of somebody filing a will, maybe not always solely, but the biggest purpose is to establish their, property rights in property that got devised by the will.
Does the probate court have jurisdiction to hear a declaratory judgment action?
I believe it does, Your Honor, yes. And I don't have the site with me today, I apologize, but I did dig into that, and I believe it is within the scope of the probate court's authority, which was why I ended up with the motion and saying I can bring this, what I believe would be considered a civil proceeding within the probate court as opposed to a probate proceeding, but still within the court's jurisdiction. According to Justin, maybe it still needs to be a petition, but I think the court has the authority to enter declaratory judgments with regard to, obviously, the subject matter within its jurisdiction.
Thank you, counsel.
Thank you.
Thank you for the argument here this morning, counsel. As is our usual practice, we will be taking the matter under advisement and will issue a written decision in due course. And with that, we will be in recess on this matter.
All right.
And the matter now before the court is Waldo 25-431, Stephen Bennett, et cetera, versus the Waldo County Sheriff's Office et al. I see counsel are present and I assume ready to proceed. We are being streamed on the web, both by audio and by video. So before we begin the argument, I would ask counsel to please introduce yourselves, and the counsel who are arguing, and together with the party you represent, starting with the appellant.
Good morning, Your Honors. Tyler Hadiniak of Hadiniak and Bascom for the appellates Stephen Bennett and Aaron Bennett Wade.
Good morning, Your Honors. My name is John Hamer, and I'm here today on behalf of Waldo County and its Sheriff Department, which are technically just Waldo County. Thank you.
Thank you. And Mr. Hadiniak, if you're ready to proceed, we'd be happy to hear your argument here this morning.
Thank you, Your Honor. May it please the court. We are here today because the trial court did not abide by the core purpose of the Maine FOA statute, to inform the public on what their government is up to.
Counsel, I see you were bold enough to leave the green light on, even though apparently this is your first appearance in front of us.
Yes, Your Honor.
But can I ask, in the second, you understand that the appeal to the Superior Court needs to be brought within 30 days. Why is your letter asking for clarification on March 21st sufficient as a request? It didn't seem to ask for anything to be produced.
Your Honor, that letter was a request to the sheriff's office to produce a fully unredacted letter.
No,
Doesn't say that.
it was a letter, it was a request for clarification of the sheriff's response to another request. There was no request for anything in that letter.
And then the sheriff's office refused to provide such clarification, which
Correct.
is a,
But what you were asking for clarification, but where in the statute are you entitled to clarification of a third party's request?
well, the clarification was construed by the sheriff's office and meant by the appellates and filed by myself on behalf of the appellates as a request for the full unredacted report. And
Didn't say request.
well, Your Honor, the sheriff's office treated it as a request, and
Did it?
Did it?
I believe they did because they refused to provide a unredacted copy and then stated that
They weren't asked to provide an unredacted copy.
they refused to provide one, and they said they would abide by any order of the court, which the appellates could then rely on to
That
appeal.
was after your appeal period. You had 30 days to appeal your February 12th denial, and you didn't do it. And then almost a month, well, several weeks after that, obviously you discovered, or Mr. Bennett discovered the redacted copy, and then you asked, why did you redact the copy that you sent, that you released to the newspaper? That's not a request, is it?
Well, Your Honor, I believe it is a request, and it was construed as one. But regardless, the issue of standing was not raised by any party.
Well, it's not a question of standing, it's a timeliness of the appeal, and that's jurisdictional for the court.
It was not an issue that the Superior Court thought.
Jurisdictional,
It is, Your Honor.
and jurisdiction can't be waived.
Correct, Your Honor. But in this case, the appellee stated in their brief that the petitioners timely filed their appeal, so they.
Jurisdiction by the court can't be waived or stipulated to by the parties.
This court could find that the clarification request of March 21st was that vital request to the sheriff's office that
The
could.
FOIA statute says we're supposed to interpret it liberally on the side of production, correctly? And that would mean we should liberally construe when someone is requesting production. So I think your position is that when you asked why did you only produce a redacted copy, you were asking again, and you're always allowed to ask multiple times, and you were asking again. They treated it like you were asking it again and said no, and if you want further relief, go to court. And so if we were construing this liberally, we would treat your request like a new request, and therefore this would be timely, correct?
Yes, Your Honor. There is no form prescribed by the Maine FOA statute.
There's liberal interpretation, and then there's rewriting your request. But let's move on to the merits for a second. What specific information are you seeking? Is Mr. Bennett seeking by release of an unredacted copy? What is he looking for?
The requested relief, Your Honor, is an unredacted report from the sheriff's office, but perhaps only the unredacted name being that of the Town of Freedom public official, not necessarily touching the private individuals who
So
were.
you would agree that any private individual who is interviewed, private person who's interviewed by a law enforcement agency in connection with a criminal or other investigation, that's confidential. You would agree with that?
In principle, yes, Your Honor.
Okay. Why is this individual, assuming that it was a town official or a public, why is that different?
Because a public official being contacted because he's a public official to speak to law enforcement is a necessarily different, has a necessarily different privacy interest than a private individual caught up in the course of a law enforcement
You
investigation.
mentioned in your brief repeatedly that a public official who's performing his official duties should be treated differently than a private individual.
Correct.
But let's assume for a moment that there was a public official or a town official contacted here. That person wasn't contacted by law enforcement because it's a public official, he was a public official, or even in connection with his official duties. It was in connection with an investigation of a criminal trespass.
Your Honor, this town official was contacted by law enforcement because that individual was a public official.
So you know who we're talking about? Does Mr. Bennett know the identity of this person?
Yes, Your Honor.
Then what are we doing here?
So, Your Honor, the sheriff's office still has an obligation to abide by the Maine FOA statute and to apply or not apply the exceptions to disclosure found in Section 804. The fact that the identity of the public official is known already actually still supports disclosure as case law fleshes out federal case.
That's the only thing that your client is interested in, is knowing the identity of the name of this particular person that he already knows who it is.
And the substance of whatever he said.
Well, the substance is recorded. The substance of what was said is fully visible in the redacted report. Isn't it?
I believe it is, Your Honor.
So it's just the name
Yes, Your Honor.
of a person he already knows
Yes.
the name of.
And more specifically, it's to make sure that the sheriff's office abides by their statutory obligation to disclose whatever information they can that is responsive to.
So this is about the sheriff's office's performance and not about the town's.
It's holding the sheriff's office accountable to make sure that they have properly applied the liberal disclosure requirements of FOA and that they did not erroneously apply one of the exceptions of Section 804.
Is there any factual record here in this case?
The factual record is just, it started with the sheriff's deputy's report.
There was no hearing before there was an argument, there was an oral presentation to the court below, but there was no affidavit. There was no other factual basis for the court to rule here, was there?
Just the parties' filings and then the oral argument, correct?
So the pleading itself, do you assert what the public interest is in your pleading?
I believe we do. I believe appellates do, Your Honor. The public interest is the public's knowledge of what a town official did or did not say to law enforcement, to the extent that they were truthful with law enforcement, to the extent that they helped the law enforcement investigation. The United States Supreme Court in Garrison v. Louisiana stated that in the pantheon of interests of the public, knowing what their elected officials are doing and being able to assess that elected official or that public official's conduct for themselves is one of the most important aspects in the public sphere.
But how is that relevant here? You have all the information substantively that's involved in this report. It's just the name you're seeking.
If we go your way and order an unredacted copy, and you have an unredacted copy, and it's, which you know what it is already, what has happened there? How is that a remedy to you? What's been remedied?
The remedy requested by the appellates was an unredacted copy. Right. Partially unredacted if need be.
Because they want the information. It's a Freedom of Information Act.
Correct.
But you already have the information, so how has anything moved forward by getting an unredacted copy, other than the fact that you've kind of spanked the sheriff's department? Is that what your objective is here?
Well, the objective is to hold the sheriff's office accountable for properly applying Maine law. So even though the appellates already know or strongly suspect they know the identity of the public official at issue, still an entirely different creature to make sure that the proper legal channels were followed and that the sheriff's office is held accountable.
Is there value in terms of holding public officials accountable and having the document itself? And is that something that we can consider within the purposes of the FOA statute? In other words, you have the information, but you don't actually have the document itself. Is that part of our analysis or not?
I think what is part of your analysis, Your Honor, is that the identity of this public official has already been disclosed. As I said, federal case law fleshes out that idea that when a public official's identity has been disclosed in the public arena, not necessarily the legal arena, but the public arena, his interest in privacy is diminished because his identity is already known.
That cuts both ways because your need to know is also perhaps diminished, right?
I'm sorry, Your Honor?
Your need to know is also diminished because you already have the information. So you could see that cutting either way.
But there's still the public interest inherent in the Blethen FOA balancing test that the public has an interest in knowing for sure.
Except what your petition actually says is that you're harmed by being deprived of the opportunity to inspect or copy it because you don't know who it is in the town of Freedom, and that you've asked the town of Freedom officials for information and they're not telling you, and you have no other recourse other than get the full report. I mean, you didn't focus on any issue about the sheriff's department.
But the sheriff's department failure to properly unredact the deputy's report was alleged in the pleadings and then, of course, at oral argument at the trial court level, and then raised and preserved in the briefs here for appeal. So that's still quite a relevant issue for this court to determine. But here, Your Honor, the trial court simply misapplied that balancing test. The trial court said that a public official has the same privacy interest, an apex privacy interest, as any private individual caught up in a law enforcement investigation. That analysis improperly assigned the same level of privacy to both a public official and a private.
If the public official is contacted not in connection with his official or her official duties, do you still look at it the same way? What distinguishes that public official from any other individual who's being interviewed in connection with a criminal investigation?
The critical distinguishing fact, Your Honor, is that this public official was contacted because he was a public official and because he could speak to what the town of Freedom did or did not authorize on the appellate's land. If he was
So
just,
it did relate to the town, what the town was doing, and that was connected to his public duties.
yes, the public, yes, the sheriff's report illuminates conduct by a town, by a government official. But the public interest here, it cuts both in favor of disclosure, not only to show what the town of Freedom, I see my time's up, Your Honor, may I finish my answer?
Your sentence.
What the town of Freedom did or did not know or authorize, but also is relevant for what the sheriff's office did or did not properly do under the FOA statute. Thank you.
Thank you. And Attorney Hamer?
Good morning, Your Honors.
So I'm going to return, since you also let the green light come on right away. I noted that in your brief and pleadings, and this is going to go to the issue of what was the nature of the March request and the refusal, or the response rather, but I think it was in your brief, you said that that the county says they released a redacted version of documents on 3/25/25. So I didn't see that. It doesn't say that in the, I think it's Exhibit 5, that's in the appendix. But there seems to be some information that in response to, it's just not clear to me, in response to the March 21st letter asking why did you redact, or to explain the redaction, that the Sheriff's Department responded by not just the letter, but by re-releasing to him directly a redacted copy?
So, Your Honor, my understanding of what happened is initially the Sheriff's Department refused the document in whole.
Right,
And then at some point, there was a different freedom of access request for
Right,
the
I understand
document, and
that.
it was redacted. And at that point, when Mr. Handiniak requested the document, it was then provided because it had already been redacted.
so although it doesn't say it, that's what your brief seemed to imply. In other words, that in the response from the Sheriff's Department, I believe it was on March 25, it's not just the letter, but there actually was a redacted copy, essentially a production of a document at that point.
I believe that's correct.
So I'd like to know how getting the name of a town official in an inquiry about the town official's official duties is intruding upon his personal privacy interests.
Your Honor, from the Sheriff's Department point of view, we have an investigation that was conducted by the sheriff. The sheriff sent his deputy out, talked to individuals as necessary to decide that case.
You basically want us to tell you to release it so you don't get in trouble, is how the Sheriff's Department's in.
Absolutely. The Sheriff's Department is very happy to comply with the Freedom of Access Act. We think it's a great purpose. It's not a discovery mechanism. But when you get down to the Criminal Information Act or the
There's nothing in FOIA or any case that says somebody who's got a pending litigation can't use a FOIA request. And actually, it happens a lot in ADBs, doesn't it? That somebody will file a FOIA.
Absolutely. I've done it myself. It's something which you do. But when you submit a request for information through this mechanism, then you have to deal with the obstacles, because who is asking for the information is irrelevant. We have to analyze this as if it's any member of the public. Any member of the public could come in and ask for this document. And so that's where we then turn to the specifics of the statute. In this case, the investigative information statute, which is very serious about protecting confidentiality. And there are a couple of things in that statute I want to point out. First is, it does say if there's a reasonable possibility that public release of or inspection would constitute unwarranted invasion of privacy. And
Of
that,
personal privacy.
correct.
So how, if you're asking the name of a town official engaging in official duties, how is that an unwarranted invasion of personal privacy?
Well, there's an assumption there that this individual was acting on behalf of the town and acting as a public official. And I'm not sure that that's the case at all. All we know is that there was a complaint made by petitioners to have the sheriff go and investigate. The sheriff sent some people out to talk to the people to whom they were directed by petitioner, and they had this discussion. So the sheriff's department is not doing an analysis of, oh, this is a public official, therefore they must have a reduced expectation of privacy.
But they know what they're investigating, and I think the underlying query is whether, one of them, is whether the town authorized this cutting. So the sheriff's office is asking a town official questions that relate to whether the town authorized the cutting. So how is that an invasion of the town official's personal privacy?
The statute talks about invasion of personal privacy. This individual may or may have not have been consulted in his capacity as select board member. This is not a high-ranking public official that has the ability to dictate what the public entity is doing.
Well, we can see, though, from the redacted report that this individual was talking about what was and was not authorized by the town select board. So can't we assume he's speaking in his official capacity? That's why he would know that information.
Not necessarily. One select board member cannot speak on behalf of the town. He does not have that authority to speak for the town. Only the town board acting as a group can speak for the town.
Well, that he's speaking at least about town business that he has information about because of his official position.
As would anybody who would be attending to any of those town meetings where this was discussed.
Yeah, but it really, is there any question that that's why he was contacted?
More likely than not, because the person was a select board member, sure. It doesn't necessarily mean that the select board member automatically has no expectation of privacy.
I understand.
Is this in a gray area?
He wasn't contacted in connection with his official duties. He was contacted in connection with an investigation. Now, the investigation may pertain to activities that went on in the town, but I think it's a stretch to say he was contacted he was performing his official duties by being interviewed for information by the sheriff's department.
Absolutely.
Isn't that fair?
I agree with that, yes.
That's what I was going to ask. I mean, I think we all agree if it had been part of an official duty, if he was in charge of a fund or something and funds were being diverted, clearly that would be an official duty. On the other hand, if he was a witness to an automobile accident, that'd be private, that'd be protected there. But when it verges into a gray area where it's not completely clear whether or not it's public or private, how do we address that? How do we balance that? If it is in any part public, that means it defaults to disclosure, or is it a weighing process?
Your Honor, I think that there's enough of a privacy interest here to meet the standard of a reasonable possibility that the release would
But the
constitute
question
unwarranted
here, the
inspection.
town official didn't just see a car accident with private people. The question is whether the town did something in the town's official capacity, and the sheriff's office is inquiring amongst a town official whether the town authorized something. How can that not be official?
Because, Your Honor, a select board member is a member of the town government. It's the lowest level of an elected official, and this person doesn't necessarily have any ability to speak for the town. If there's going to be an investigation and the sheriff wants to go and speak to the
But why did they
select board.
ask him then?
Because this person in their individual capacity had some knowledge that was,
How did he get that knowledge? Because he was a town official, correct?
that's, Your Honor, that's not an inquiry that the sheriff is going to make. The sheriff is going to take a look at the parties, and is there a possibility that this could implicate personal privacy? And once that's yes, then you go and the sheriff denies it, and the Superior Court goes and then applies the balancing test. And that's what happened in this case.
So when we apply the balancing test, which is prescribed under Blethyn, you take the private interest at stake and you balance that against the public interest that's at stake. The private interest, is there a private interest, privacy interest here on the part of this particular official? And if so, what is it? And then what's the countervailing public interest? And we're only talking about identity. We're not talking about any information that he knows. The only thing that the plaintiff is seeking here is his name. So what's the public interest? What are those? How do you balance those two interests?
So to start with the privacy interests, I think there's plenty of case law that explains what the privacy interests are, and the Superior Court went through them and did find that the individuals all have a significant privacy interest because they were interviewed by the sheriff, not of their own accord, but because the sheriff came to them, and they all wanted to stay out of the subject as much as possible. They don't want their information shared, and they don't want their information broadcast. So I think that there is a significant private interest. When you turn to the public interest, there's a question of then, is the central purpose of the freedom of access law being furthered? And the Superior Court found no, that it wasn't, that this really pertains to a private dispute between perhaps the town of Freedom, perhaps individuals, and the Bennetts. And
So there's a private dispute between an individual and the town?
that is my understanding, Your Honor, is that
Isn't the town the town?
the town of Freedom, correct?
Okay.
So do you know the status of that?
I don't, Your Honor.
How can that ever be private? I mean, if I'm a taxpayer in a town, don't I have a right to know what sort of litigation or disputes my town as an official entity is involved in?
Sure, but not
What's the
through
privacy interest there?
I'm sorry?
What's the privacy interest there?
The privacy interest is of the individual who's been approached by the sheriff, asked for information. This individual,
But your position is, well, he's not really acting on behalf of the town, but then doesn't that actually raise a different problem, which is if he's purporting to act on behalf of the town but can't, then that's a problem. I mean, that's exactly the kinds of things that, isn't it, that the FOIA request should be able to get at?
there would be no statement from this individual for the sheriff's office coming and saying, we have these questions for you, and I'm questioning you because the appellant has asked me to go. and
Right,
talk
but
to
isn't
you.
that very issue as to the extent to which this person may or may not have been acting officially on behalf of the town? Isn't that part of the information? To the extent it's revealed in the sheriff's report, I understand it's not an investigation of that issue, but isn't that important?
My position continues to be that an individual select person doesn't have the authority to act for the town, and so consulting with an individual.
But that
wait.
individual has certain knowledge as a result of his position as being a select person. And you focused on the fact as to whether or not there's an investigation going on, and as a result of that, it would constitute an unwarranted invasion. Unwarranted, given the fact that this is an individual, as by virtue of his position as a select person, has knowledge that may relate to this criminal activity?
I think it was unwarranted, Your Honor, and
How so?
I think that the Superior Court Justice who went and evaluated and applied the test, the balancing test, was fair in application of the rules. The Sheriff's Department has
He has no independent actual, evidentiary, it's not like he made factual findings or something like that. I mean, isn't there, should we give any deference to his application of the balancing test?
I think that balancing test should be considered to the extent that there are any facts, and there are some facts which the Superior Court.
That's the question I'm trying to get in here. Obviously, this is based on facts. The redacted copy lays out, I believe, all or most of the facts except the identity of the person? What's the factual
Identity
record
of
we're working
individuals were redacted. That was the only thing that was redacted, I believe, from the report. The unredacted report was provided to the Superior Court. So the Superior Court had the whole picture when it.
So is the factual record the four corners of the redacted report? What other record do we have here? We're talking about the relationship and someone did that. Is that something we'll find in the record?
No.
No, I didn't think so. So it's the four corners of that. So if the document is produced with the exception of the name and you apply the balancing test, all that really is left there is whether or not the individual has a stake in their privacy interests there. Is that incorrect?
The Sheriff's Department.
The burden was on the sheriff to show that the exemption applied, and we're supposed to apply it narrowly, correct?
Yes, that is correct.
So it was the sheriff's office burden to show that there was a personal privacy interest.
The Sheriff's Department was complying with its statutory mandate under the Investigative Information Act.
But under the Fairfield case, I mean, the agency has the ultimate burden to show why it's a just and proper denial. But the requester under the Fairfield case must demonstrate that the information sought is likely to advance a significant public interest.
Correct.
What's the public interest in the name of this individual?
That's a good question for the petitioner, because I believe that's.
I think I've asked that, and I'll try again.
Because I think his answer is none.
Correct. Thank you.
Thank you. Attorney Hadiniak, you reserved a couple minutes for rebuttal.
Yes, Your Honors.
Can I start with that question again? What is do you think you have demonstrated that the information sought, namely the name of this town official, is likely to advance a significant public interest? The name, not what he knows, not what he said, the name.
Yes, Your Honor, because the public can then assess for themselves, putting the name in context with what the town official said.
But don't they already know the name based upon the other information that's been published?
Yes, but
So then how do we get any further? Because what you just said was they need to know the name. through other means, they know the name. What's left to be done?
There's a concurrent interest in having confirmation of what is already understood by the public to be the identity of this official, and that confirmation would come in the sheriff's report. But, Your Honors, I do want to address this possible jurisdictional concern. The letter from the sheriff's office responding to my letter of March 21st, it's page 32 of the appendix. That letter is where the sheriff's office explicitly states that any further appeal should be taken in accordance with, and then it cites the section of the Maine FOA statute. I think, or appellates think that this court should reaffirm the liberal basis on which requests can be made to an agency under the FOA statute to find that a appellate like the Bennetts in this case had a right to rely on that sheriff's office representation.
Was this letter accompanied by a copy of the report? I believe that's what the attorney for the sheriff's office just said, but is that your recollection that they sent another redacted copy when they sent your client this letter?
The sheriff's office provided they first provided the appellates with I'm sorry, Your Honor.
Go ahead and answer.
With a completely redacted copy, no legible words whatsoever. And then upon this request, there was only a partially unredacted copy, but still did not address any of the identities.
So in their response of March 25th, they also enclosed a redacted copy. I understand it, you don't think it satisfies their obligation, but they enclosed the redacted copy.
I believe that is the case, yes.
Thank you.
Thank you.
Thank you, counsel. As is our usual practice, we are going to take the matter under advisement and issue a written decision in due course. Mr. Hadiniak, it's my understanding this is your first appearance in front of this court. And as is our custom, we invite counsel back to take the greetings of the court in our conference.
All right.
and is it still morning? Good morning, you can be seated. I'm sorry for the delay. I think we didn't quite allow enough time, I guess, this morning. The matter before the court now is Hancock 25333, State of Maine versus Jesse Pelletier. And I see counsel are present. I'm assuming ready to proceed. We are being streamed on the web, both by video and by audio. Before we begin the argument, I would ask counsel to identify yourselves by saying the name of the party you represent together, saying your name together with the name of the party you represent. And Mr. Tofflin, if it's challenging to remain standing, you don't have to. Attorney Pratt, if you're ready to proceed, we'd be happy to hear your argument this morning.
Thank you, and good morning with 15 seconds to go. May it please the courts.
And I see that you decided to not protect any time, although there's not a green light on. But now there is. And so I'm going to jump in. Why are we talking about hearsay exceptions? How is this hearsay in the first instance?
It's hearsay because there's one individual, Ms. Cornell, who overheard the alleged victim speaking.
Right. But not every out-of-court statement is hearsay. How is this being offered for the truth of the matter asserted in the statement?
Well, it's being used to corroborate the statements made by and the allegations made by the alleged victim.
I understand that. How is it being offered for truth of the substance of what is being asserted in the statement?
Well, I think I'm sort of struggling with the word how here because, I mean, it was introduced by the court. The court considered it for the underlying events itself and as corroboration. The trial court in the...
Was it being offered to prove that she had a boyfriend?
Was it being offered to prove she had a boyfriend?
I mean, the statement is, there's two statements really, but one of the statements is, I have a boyfriend.
Yes.
Was it being offered to prove she has a boyfriend?
I believe so, yes.
And so it matters whether she does or does not have a boyfriend?
Even in this instance, it does. And I would say more importantly, the one about saying no is clearly being offered to prove the truth of the matter asserted here. She's alleging that it was
Isn't it being offered really to prove that she said it? I mean, the witness that's testifying doesn't have any knowledge about, what's true or what isn't, and couldn't testify as to that.
Could certainly testify that she heard a statement being made, but she could not testify to the content of that statement. That's where the issue that we run into in this particular case. So she has particular knowledge that a statement was made. She does not have particular knowledge about the underlying facts or what was happening during when those statements were being made.
That she testified of what was happening in the other room?
No, but that's what the judge took it to mean. And that's what the purpose of those statements were, to show what was happening in the other room at that time. And that's why the judge found it as a hearsay exception under present sense impression. That's how he came to that conclusion, because it was being used as corroboration to the events that were taking place in the other room.
You do agree, if we disagree with the basis upon which it came in, but nonetheless that it was permissible for it to come in, that we can still affirm on that basis?
Certainly, but I think that some deference, as this court loves to point out to the defense, that this court gives great deference to the reasoning and thought process of the trial court judge. And in this instance, he rejected all other forms of how it could come in and settled on that it was present sense impression, which is why it's the focus of my presentation. But I'm happy to address
Counsel, I'm struggling with this notion that no, nothing's happening or no, stop is hearsay. I mean, I wouldn't do this, but if I said, go sit down right now, that's a command or an instruction. There's nothing true or false about my statement that someone could prove. So how is her saying, no, stop, asserted for the truth of anything?
Well, the judge, in order to find Mr. Pelletier guilty, used this as corroborating fact. So he used it as a substantive piece of information that was not just...
But didn't he, to be clear though, didn't he actually use it as a corroborating fact that it was said? And then he had to interpret what was meant.
I would agree with both of those statements, but it's then interpreting what it means, and that he took that to be a fact that was I would say is clearly used as a hearsay statement to prove an out-of-court statement in this instance, which
Counsel, I mean, one of the issues in the case, correct, was whether the victim acquiesced and whether Mr. Pelletier was at least criminally negligent in believing that she had acquiesced. And so the victim testified that she said no, and then the friend testified that she heard the victim say no. And so how is saying the word no being offered for the truth of the matter asserted? Isn't it just being offered to show that the victim said those words to Mr. Pelletier?
no, I think it's being used to offer to show that there was no acquiescence, and in fact, the opposite. But I would say that in this instance, the reliability of the statement must come from the timing and not the narrative consistency.
Well, are you saying that Ms. Cornell was lying when she said that she heard the victim say no, or that there wasn't sufficient evidence in the record to establish that she could hear what the victim said?
No, I'm not disagreeing that she heard what the victim said. What I'm saying is that the timing of what she heard is unrelated to the event itself.
Well, except didn't the victim said that during the event she said the word no, correct?
But what she testified to was that she said no, and then she tried to go to sleep, and that then the defendant sexually assaulted her. She then said she got up and went to Ms. Cornell, who was already asleep at that point, and had to wake her up. So it clearly indicates that there was a difference in time between what Ms. Cornell heard and the alleged sexual assault.
But that's based also on a same gap that the victim is alleging, is what you're saying. And that really, again, just goes to the weight of, from your client's perspective, if she said no a long time ago, is that still in effect or something like that? I mean, it doesn't go to whether it was said, which is the issue with Ms. Cornell.
Let me go back and say that if it goes to, if this court is rejecting the lower court's interpretation that this was present sense impression, and instead are focusing on that it's non-hearsay because it's not used to prove the truth of the matter asserted, my counter to that, which again, I did not really address in my brief because it was not.
But I know that you're a brilliant lawyer and you're going to address it right now.
So I would say that then this would be that this was under two things. One, it's not relevant. And two, it would be overly prejudicial to any fact finder.
How is it not relevant that the victim said no?
Because it's not no in regards to the sexual assault, it's no in regards to something that's unknown, that happened at an unknown time frame.
Well, but couldn't you draw an inference? The victim said that she said no during the event. And so couldn't you draw an inference that when Ms. Cornell testified that she heard the victim say no, it was during the same time period?
Well, I would say no, because you cannot use inference when deciding foundational questions. I think the rules of evidence are clear that you need actual foundation, not inferences.
Foundation for what? For the introduction of the testimony that she heard the victim say no?
I would say introduction to why that is relevant. And why is it relevant when it is not relating to the sexual assault? It's not related in time. It took place at an unknown time earlier than it. So the only purpose of it would be overly prejudicial. In this instance, it was so prejudicial that a judge, not a jury, determined that it was the key corroborating piece of evidence to convict Mr. Pelletier. That by itself shows the prejudice and that it was used for the truth.
I don't understand why, you may have had a different view of the fact, but why couldn't the court draw the inference that it was at the same time? In other words, Ms. Cornell overheard the victim saying no in regards to the sexual advances.
Well, I would say based on the testimony of the two witnesses, Ms. Cornell and the alleged victim, which clearly shows that there was a difference in timing between the no and when the assault took place.
And that's a different issue. I mean, because Ms. Cornell's testimony by itself doesn't say, and I heard this while she was being assaulted. I mean, it's the victim that you're saying that the testimony of the victim and the defendant that set up that there may have been a gap between when that was said and when the assault took place, but then that's for the judge to resolve that issue.
Well, I don't think it's just for the judge to resolve. I mean, I think he needs to determine it based on the evidence that's presented to the courts. And I think to resolve it to say that she was saying no when the assault took place and that was overheard would fly in the face of the evidence that was presented.
But even leaving aside you're talking about the substantial contemporaneity issue.
Yes.
But even setting that aside, if she had said no at an earlier time in the evening, rejecting his advances, wouldn't that still be relevant? Maybe not the same weight as contemporaneous,
No,
but wouldn't that still be relevant? That
no,
she-
because we don't know the context of what she was saying. The witness heard her say no and said something about a boyfriend, but it could be, no, I don't like X, Y, or Z, and I have a boyfriend. We don't know that it was in the context to a sexual assault or a sexual
But
advance.
don't we know that she heard it after Ms. Cornell had gone to her own bedroom? Didn't she testify that she heard the victim say no when she was in her bedroom and the victim and Mr. Pelletier were out in the adjacent room?
Yes.
So doesn't that put it pretty close in time to the events? I mean, this isn't something that happened, earlier in the evening. This is something that happened after everyone had left the party and Mr. Pelletier and the victim were in one room and Ms. Cornell was in the other room.
I have no idea because the record is unclear. It could have been 20 minutes or 2 hours. That's the whole point. We don't know. And the fact that we don't have any information about whether it was contemporaneous or close to contemporaneous is the heart of the issue. The trial court never made that determination. There was no testimony about that issue. And in fact, the facts that are presented and testified to suggest that it was a significant period of time, given that one, the alleged victim started to fall asleep.
But you're
and that
you're tying everything to the actual sexual assault itself, that it had to have been spoken at the time of the assault itself. Wouldn't we look for context over a longer period of time? I mean, the statements of, hey, nothing's happening, and then the no later on. If we look at the entire sequence that may have occurred over minutes, many minutes, the context would suggest that even if there was a no spoken along with nothing's happening, why wouldn't that be relevant? And when we look at substantial contemporaneity, rather than narrowing it down to the time sequence of the assault itself, to the larger context that led up to the assault.
Well, I believe that this court has never put a bright line rule, right, as to how many minutes.
Right.
But I think that the court has indicated that there needs to be some knowledge as to what that time frame is. Here, we have zero knowledge as to what that time frame is. Absolutely none.
Well, it was the same night, right? I mean, memories can be difficult, as we all know. There was alcohol involved. I mean, why don't we defer to the court as a fact finder to conclude that it's, contemporaneous enough that it's relevant?
Because I don't think there's any facts to support it. Again, I think.
But again, it's the same night, right? You would
but
agree
it's-
with that?
Same night could be 2 minutes or 9 hours. I mean,
What about the fact that,
No, it wasn't 9 hours.
I was being hyperbolic to
what about the fact that Ms. Cornell was so concerned about what she was hearing that she sent a text message to the victim asking if you're okay? Doesn't that suggest that this no just wasn't some innocuous, are you going to the game tomorrow?
No, I actually thought the exact opposite, which is if I hear someone in another room and I think they're being sexually assaulted, I sure would do more than send a text, you okay? I'd probably go into that other room. I may even call 911. I think that fact actually cuts in favor of the defense.
It may cut the other way because we're talking about context again. The testimony was, so they were having some casual conversation. Alice was talking about stuff back home. It seemed friendly. I could tell that Jesse was trying to flirt with her. And then, Alice was like nothing's happening. Like, I have a boyfriend. She brought up her current boyfriend, Mike. And then they just kept talking casually, and I heard her like, no, nothing's happening. Like, no. That puts some context on this for the judge, who was then taking all the other evidence in, and would be consistent with somebody sending a text message to suggest, are you okay in there?
I certainly agree with that. What I'm saying is it's not consistent with suggesting a sexual assault was taking place at that time.
I said context. I didn't say the assault was taking place at that point.
I certainly agree. It puts it in context, but
Finish.
But I would certainly say that it doesn't, as I said earlier, not that it falls within that a sexual assault was occurring or that it would satisfy the conditions of a present sense impression like the judge determined it did. Thank you.
Thank you. And Mr. Tofflin, we're happy to hear your argument.
Thank you. Justice Stanfield, I think your first question of my colleague goes to the heart of the case. Why are we talking about hearsay at all? You don't have to consider the hearsay arguments to decide that this verdict should be upheld. I refer you to page pages 22 and 23 of the transcript, Maine's juries, and in this case it was a judge who was the fact finder, they're routinely instructed the testimony of one witness can be sufficient if you view it as credible to support a conviction. And here, Justice Stewart said on page 22, in short, the court finds Van Coven's trial testimony to be credible. And on the next page, he says that Van Coven's conduct afterwards is consistent with her not acquiescing.
Mind you that we don't ordinarily say victims' names in a public proceeding.
I apologize, okay. But quoting from the transcript, which I finished doing, Justice Stewart talks about the elements of the crime. He didn't reach on 22 and 23 the negligence, but that was treated elsewhere, but found the victim's testimony in and of itself, uncorroborated by any claimed hearsay, to be sufficient to sustain a conviction. And that is the just result. With that, I'll take questions if you have any, please.
I appreciate the fact that you liked my question about whether it was hearsay at all, but you didn't make that argument. I mean, you were arguing an exception to the hearsay rule.
And I'm respectfully not sure that that's relevant. I defended what I had to defend in the heat of battle, but in the more academic environment of a law court presentation, I can certainly argue that the whole issue of hearsay is, I won't characterize it as a red herring. Mr. Pratt is a brilliant lawyer. He does good appellate work. But it's a distraction from the way this court should support the verdict, which is straight up, the fact finder believed the victim and found the elements of the crime.
Well, you agree that the evidence that, of the statement made by the person in the other room was definitely played a role in there may have been other evidence from which the judgment could be sustained, but there's no question that the trial justice used the statements that Mr. Pratt is complaining about to support his judgment.
I concede that, and I don't want to just belabor the point I'm making, because I don't think that hearsay was admitted here. But again, this case, respectfully, at least in the state's view, is easily decided without any consideration of hearsay because of the victim's statements, and the corroborating physical evidence too.
But that makes me, it sounds to me like you're making a harmless error argument.
I think I am.
So you think it was error to have admitted the statements?
No, but if you think it's error and that's the only opinion that counts, your collective wisdom, it's still harmless. But I've said really everything I wanted to say on behalf of the state in my written submission. I would be happy to respond directly to questions about the application of the rules.
Do you agree that Ms. Cornell's statements were not admitted for the truth of the matter asserted?
I believe they were admitted to corroborate, as the court has discussed with Mr. Pratt, the central statements of the complaining witness, of the victim.
But the question is whether you agree that those statements were not being offered to prove the truth of the matter, but simply to show that the victim had in fact made those statements.
I'm happy to agree with that, Justice, because it seems to align with perhaps your thinking. But going beyond that, I also think that they could have been admitted for the truth because they were not hearsay.
And what's your argument as to why they were not hearsay?
Because they were statements offered, as Justice Stewart pointed out, squarely within the purview of Rule 8031.
What is the truth that they're being admitted for? What's being proven by the four corners of what was said?
The statement by the victim, no, which was indicative of her resistance to the sexual advances, flirting of the defendant.
Well, the statement's offered to prove that she said no. It doesn't carry with it the context we were talking about previously.
It may or may not, but that's up to the fact finder. I disagree with Mr. Pratt when he says the foundational issue can't be decided with respect to inference. We tell juries all the time, you folks have each instructed juries and told them
Well, let
You
me just
can
give you
apply
another,
common sense.
to give you another semi-hypothetical example. She said, I have a boyfriend. That being, was the fact of whether she did or didn't have a boyfriend, was that a material fact in dispute during the course of the trial?
No, it was
Oh,
not.
it was not. So it's not being admitted to prove that, which means that the truth of the matter being asserted is not what is being offered to the court. It's just the fact that it was said. Maybe we're going in circles here.
I don't think we're going in circles. I think the state's trying to have it both ways. The state's arguing to you that it's not offered for the truth, if that's what the court thinks is the way we're going here, or even if it is offered for the truth, it's not hearsay because it falls within an exception.
How is it a present sense impression? I mean, a present sense impression is when the declarant is describing something that's happening contemporaneously, and the witness is saying what the declarant was describing. In this case, the victim wasn't describing what was happening to her. She was saying things like, no, I have a boyfriend, this is not going to happen. So how does this fit within the present sense impression exception to hearsay?
I think we're defining the present sense impression exception a little more narrowly than it was intended to operate, and that is that any, I won't call it an excited utterance really, but any affirmative action that's connected to an event which is alleged as a crime becomes, if it can be corroborated by immediacy by a separate witness, it becomes non-hearsay.
Even
Doesn't
if
have to
those
be the
statements, I mean, even though the rule says that the statement has to be one describing or explaining an event condition made while or immediately after the declarant perceived it. In this case, that's not what the statements were.
Well, I disagree with that, Justice. I think it is explaining a condition. It's explaining a condition of the relationship, the dynamic between the assailant and the victim.
Putting aside the hearsay question, can you address Attorney Pratt's argument that the statements lacked relevance because there's some gap in time between what Ms. Cornell says she heard and what the victim testified happened? Just help me understand, I guess, what the record evidence is in that regard.
Sure, I think that's frankly a tortured argument. It is abundantly clear from the record before the trial judge that all of these events related to a compressed period of time in which the victim was being confronted, as it were, by the.
And so I assume your position would be that although Ms. Cornell obviously can't say what exactly was happening at the room at the time, it would be for the trial court as a fact finder to make inferences that what she heard was or corroborated what the victim said.
And those inferences are perfectly reasonable based on what Ms. Cornell was able to tell the judge specifically, and that is, I went to bed at 1 o'clock and the living room was adjacent to my bedroom and the defendant and the victim were in the living room together. The record read as a whole can only lead to the conclusion that the event that Ms. Cornell was listening to was the event that the state charged Mr. Pelletier with.
Counsel, can I ask an unrelated question? I noted that in your brief there was no statement of facts or record citations contrary to the rules. Is there a reason for that?
I think that I'll of course yield to the court in its application of the rules, but the statement of facts is required when there is material disagreement with the facts as articulated in the appellant's brief.
So you're saying that by simply not saying anything that's your way of adopting the appellant's statement of facts?
We again focus on materiality. I think Mr. Pratt has always done a fair job of outlining the pros and cons of the evidence before the trier of fact. And I disagree that there were no record references. When I went through the portions of the transcript which related to Ms. Cornell's testimony.
There was no statement of facts with record references.
But I will remember that, Justice Stanfield, for my next brief.
Okay.
Well, when you start making record references in your argument, it's helpful that you had a statement of facts that had those record references in them.
The law court's message has been received.
There don't appear to be additional questions. Thank you.
Thank you.
Attorney Pratt.
Thank you. I believe I may have struggled with some of the court's questions because we're sort of in a murky area, in my humble opinion, where the lower court said that it was present sense impression. I get the impression from this court that you are saying it's not present sense, it is non-hearsay. The difficulty is that the reason that I was assuming that we would be talking about is a hearsay exception, one of them, is because the trial court judge treated it as substantive evidence that came in to prove the truth of the sexual assault. I think that is undeniable based on his decision. And
There's no question that he relied on that information as corroborating evidence.
So then the question that I'm sort of struggling to answer for all of you is, if it is non-hearsay, but it is coming in to prove the truth of the matter of the assault, what does that do with his decision? And I would say that would make his decision in error, in that it was based on improper decision-making, that it was...
But if it's not hearsay, is there a limitation as to the purpose for which it comes in?
I don't think it can be used for the truth of the matter asserted, despite what...
Well, if it were being used for the truth of the matter asserted, it would be a hearsay.
Well, no, I'm saying that I think the judge was using it for the truth of the matter asserted based on the way he describes it in his decision.
Well, he was using it to establish the truth that a sexual assault had taken place.
Yes.
Or more specifically, the truth.
But that's different than offering it for the truth of the matter asserted in the statements themselves.
More specifically, the truth that the victim communicated that she didn't consent is really what
he
is being used.
specifically is using it, as the justice said, to indicate that the sexual assault took place, which I think is the truth of the matter that is the heart. He describes it as her saying no is evidence that the sexual assault took place. Thank you.
You can finish your thought.
That the sexual assault took place, which I think is clearly not being used as a non-hearsay use, but used as a hearsay use.
Okay.
Thank you.
Thank
I
you.
apparently should have stopped the first time based on that.
I'm just trying to follow the argument that you just made, but
Thank you, Your Honor.
thank you. That's what that face was, is I'm not sure I followed that. Thank you, counsel. I'm afraid, as is our usual practice, we will take the matter under advisement and issue a written decision in due course. Thank you for your appearance here this morning, and with that, we're in recess for the day.
All rise. All persons having anything further to before the Honorable Justice of the Court, sitting as a law court, may finish the court and give their attention to that court that calls Chief Justice. This court now stands adjourned.